Hi everyone, thanks for listening in today to hear about the common HR and payroll compliance issues on private transactions. I'm Chelsie Harris, leader of the private deals team at PwC, and I'm pleased to be joined by Sally Woodward, who's a partner in our workplace law team and leads PwC's legal business. So Sally, people are an integral part of any business. Why is wage compliance for businesses thinking about a future sale or purchase so important?
Thanks, Chelsie. Look, there are a few different ways to answer that question. On the one hand, paying people correctly is inherently linked to labour cost. If employees have been overpaid or underpaid, this can have a significant impact on labour cost and whether a business preparing for sale has been valued correctly. Of course, where an underpayment comes up in the context of deal diligence, this can have an impact on deal price, both in terms of one-off historic liabilities and adjustments that need to be made, but also in terms of ongoing impact on future earnings. And there may also need to be additional investment in relation to systems and processes. More fundamentally, of course, paying employees correctly has a significant impact on culture, innovation, and incentive within a business. Where there's a risk that employees have been underpaid, this could have a real impact on reputation and brand value.
So how does that play into private clients? For example, a small business or founder transaction where a founder is looking to get ready for sale. How should they be thinking about risk?
So it's important to note that wage compliance is incredibly complex. In Australia, we've probably got one of the most industrially complex systems in the world, and workplace laws have changed significantly over the last 18 months. It's really common in small family or founder businesses to assume that paying people, commercial rates that are above minimum wages will be enough to comply. Often these types of businesses are pretty generous. There's a lot of trust in how people are paid, how they take leave, etc. But what we have to remember is that once a business like this gets to sale diligence, a buyer wants to look at records. They want to see technical compliance in contracts. They want to see that appropriate advice has been taken. They want to see that there are proper remuneration structures and the like. And small to medium enterprises might be working significantly on the basis of trust and, as we say, paying above minimum compensation, but without the appropriate paperwork. And that can lead to technical non-compliance. And technical non-compliance can still significantly impact value, and it will also impact whether or not warranty and indemnity insurance might be available and the like.
So it sounds like getting your records, contracts and other items in place is really critical.
Absolutely, that's right. A business needs to be able to demonstrate through records that it understands all of the minimum obligations that apply to its employees. So that includes, for example, knowing what award your employees are classified under and how those employees fit within the specific classifications under the award. It also applies to worker type. So a really common issue that we see is the misclassification of employees and contractors, and the misclassification of casual employees instead of being permanent employees. So federal laws have changed significantly in relation to both of those areas within the last 18 months.
So doing a review of your documentation early and plugging the gaps is really important.
Absolutely.
Yeah. And Sally, you mentioned that employers might seek to meet minimum award arrangements by just paying above minimum wage rates. Is that enough?
Fortunately not. An employer and an employee need to very clearly agree to that type of arrangement. The contracts of employment need to be really carefully drafted and include robust set-off provisions that enable those above award payments to be set off against minimum award obligations. So having good contracts becomes very important, and it's also really important that an employer keeps records of the hours that employees are working so that it can ensure compliance and assess that it has been paying employees above the minimum rates for the hours that they are working.
And so what happens if in getting ready for sale an employer finds an issue? What should they do?
It's not uncommon. We see it a lot. Getting ready for sale early, starting the process early, helps provide enough time to find and address those issues so that the impact is known and the steps for rectification can be agreed. And it's really good to get this out of the way before settling on earnings that then form the basis of discussions on valuation and sale price.
So thanks so much for the insightful conversation today, Sally. From our discussion, there are 3 key takeaways I'd like to highlight. Firstly, time frame. You've given us a few key items that need to be in order, but getting these in order early is really key. Being able to demonstrate that you know your minimum obligations. Businesses should have good records to show that they understand what awards apply to their employees, what their minimum terms are, and how workers are getting engaged, including contractors. Get your records in order. Make sure you have documented arrangements, particularly contracts. Simply paying above minimum wage isn't enough.